Good afternoon. The question for today is, why are clients willing to pay for coaching during divorce litigation? And I want to talk a little bit about the answers. The primary answer is because even though feelings don't matter to lawyers, feelings really do matter to our clients. You shall know the truth, and the truth shall set you free. That's a quote from the Bible, and it's a basic fact about life and about how people's understanding about their experience really does help to set them free. For more than 35 years now, since my third year as a law student and a clerk for a boutique family law firm in Dallas, I've had the privilege of listening to family law clients tell their stories. And some of them are sad and some of them are frankly tragic. Some of them are truly funny. But almost all of them involve the client expressing their deepest feelings about the experience they're going through in their deteriorating marriage and their divorce. In my role as a divorce litigation consultant, beginning in my third year in law school, I've had the opportunity now to listen to hundreds of these stories. And there's some things I've learned about what's important to clients that I want to share with you. As a pioneer and innovator in this unique niche in the litigation consulting business, I frequently have to help family lawyers figure out a way to explain the value of my services to their prospective clients and to clients who have already hired them and are trying to figure out whether or not it's a good idea to add the expense of my fees to their already burgeoning legal fees. As litigants have become more cost conscious, the conversation has become increasingly more pointed, and the questions about the value of added services become more important to the client. Family law litigation, especially at the level in which I operate and my clients operate, is an extremely expensive proposition. And so a few $1,000s of added expense is something that people carefully consider. The reluctance of lawyers to talk to their clients about hiring me is a combination of business prudence. They know that their clients are already paying a lot of money for legal bills for expensive divorces, and a failure, frankly, to understand the depth of the emotional meaning and importance to the client for being able to perform at a high level and to have the opportunity to tell their story, who somebody can help understand their experience in their divorce. Most of my clients feel horribly victimized by a system that they can't control. Most of them are C-level executives and professionals who are used to being in charge of the systems in which they operate, and so they feel particularly victimized by the legal system, where they're basically passive recipients of whatever the system dishes out to them. And some other of my more empathic lawyer friends have just admitted to me, look, I don't really want to listen to that stuff, and that's why we hire you. And I'm okay with that, because they know that the information I'm going to glean from the client is different from the information they're likely to get, and that the information is likely to help them present a better case and increase their chances of winning in trial or in hearings or even in negotiating a better deal in mediation. As a shrink who operates in a world full of trial attorneys, I've taken a fair amount of mostly good-natured ribbing about being interested in the client's feelings. And to be honest, there are times when the attorney part of me doesn't care much about those feelings either. But recent advances in brain imaging have provided the basis for what psychologists and psychiatrists have been talking about for literally almost 100 years now. And it is that feelings do have a basis in the brain, and that now we have improved imaging techniques. We can really help to understand and identify the effects that those feelings have on people's ability to think. The research that I find most interesting exposed clients who were already hooked up to a whole number of sensors to a very stressful situation that was very confusing and very chaotic. To my mind, a perfect analog for family law litigation. And these folks, when the sensors were turned on and the images were transmitted to the screens, their brains looked like their world looked, which was completely chaotic. The brain waves were chaotic, unpredictable, wild looking. and so the screen was a good reflection of the person's internal emotional state and of the state of their brain. And what the researchers found was that the minute, and we're talking about within milliseconds of the time when someone helped the person identify accurately the feeling that they were experiencing, whether it was fear or confusion or chaos or feeling overwhelmed or feeling sad, whatever the feeling was that they were experiencing in the experiment. Once that feeling was accurately identified, their brain completely transformed from this chaotic mess to what scientists would describe as synchronous brain activity, which is slow, reliable, predictable, sine wave looking brain waves, and the people in the experiment, the participants in the experiment, were similarly reporting that they felt relieved and comfortable and more at peace. And so this a little piece of brain research really is a way of identifying the value of identifying feelings for family law litigants, in that if people are unable to accurately describe their feelings, which are changing from minute to minute, second to second, and go on and on for a period of the entire period of the litigation and for some time after, that identifying those feelings can help people feel more comfortable and at peace. The second thing is labeling feeling. I mean, the bottom line for this lesson is that labeling feelings helps the brain to organize itself, and we now have brain imaging research that documents the strength and the power of that effect. The other value that I found that coaching brings to family law litigation comes from lessons I've learned from my clients, and that is based on just one basic fact. 2/3 of all the people in the United States describe public speaking as their greatest fear. And as we all know who practice family law litigation, it's impossible to go through litigation without going to court at least once, even if it's just for a temporary hearing for 15 minutes. Everybody has to show up and publicly testify about what it is that they want for their children and their families. For most people who don't operate in the legal system, this is an incredibly terrifying experience, and for which they're completely unprepared. And consequently, as you hear from both lawyers and judges, people who are not prepared to testify poorly, and sometimes in a way that actually hurts their case more than helps it. So what's happened is that as a result of my background and experience now, I have become a coach for these people who are getting ready to appear in the legal system and who have significant fears about whether or not they can participate effectively, speak effectively, or even speak once they get on the witness stand. And to add to the pressure, many family law litigants believe that if they screw up their testimony, that they'll lose their children, and there's some truth to that. It does happen from time to time, where a single episode of testimony can lead to the judge making a rapid decision to change custody or to significantly restrict somebody's access to their children. So the fear is not completely unreasonable. It happens. So what I found is that when you teach people some of the rules of evidence that are relevant to their testimony, when you teach them about the nonverbal strategies that are important in looking confident and being persuasive in court, and then when you give them opportunities to practice those new skills and to develop a sense of confidence about them, that their ability to actually participate effectively at a high level in court is significantly improved, and people go from being terrified and terrible witnesses to being confident and persuasive witnesses, and able to talk about the things that are important to them as they try to convince the court that whatever it is they want from their family law litigation experience is something that they should reasonably have. Most of the time, what I hear from my clients after cases are over is that they wish they'd hired me sooner, that they could have avoided a lot of angst and stress, and that understanding how the system works and what their participation in it could be was probably one of the most helpful things that came out of the litigation for them. As family lawyers, it's easy for us to minimize or ignore or brush off the messy and sometimes demanding emotional experiences of our clients. But we just need to remember that the client's willpower is really not the issue. People have the ability to change their behavior if they're given the tools and the ability to understand the system that they're operating in, and that most of what happens to them, if you just remember the research I just told you about, that a lot of what happens to them is the result of things that are going on in their brains. It's not about their willpower. So these two basic facts, that people are afraid to testify in court because it's one of their greatest public fears, or greatest fears of speaking in public, and that people who don't have the skills or understanding about how the system works in which they're called to operate as a witness really are at a disadvantage, and don't operate or don't perform as well as people who have the skills and have had an experienced coach teaching them what to do. So now that you know the truth can set you free and your clients free. So call me. I'm happy to talk to you. Have a great day.